Today we are discussing on rule of law. We have to understand the difference between the rule of law and rule by law. At the very outset of this discussion, we need to explain what we mean by the term law. John Austin defines, law is the command of the sovereign. Rousseau said, a law is a resolution of the whole people, for the whole people, touching a matter that concerns all. Such a definition highlights the virtues of democracy. T.H. Green views, law is the system of rights and obligations which the state enforces. We are not attempting to put a wide range of definitions, but observing that law is the command of the sovereign, the law is the will of the people, the law is the foundation of rights and obligations, which regulates human life as a social being. Law has a close link with morality, ethics, customs and practices. There are different types of laws, such as personal laws or private laws, public laws, constitutional laws, ordinary laws, common laws, and administrative laws. In a simple sense, law is the fundamental principle of the governance of society. The word law is derived from the Old Teutonic root lag, which means fixed or uniform. Now, let us come to the word rule of law. Rule of law is a common word today, especially in Western democracies. The West hailed their democracies built upon the foundation of freedom under rule of law. Chinese President Hu Jintao observed that we must build a system based on the rule of law and should not pin our hopes on any particular leader. Robert Mugabe, President of Zimbabwe, stated that only a government that subjects itself to the rule of law has any moral right to demand of its citizens obedience to the rule of law. The phrase rule of law, uttered in many places by many leaders, is democratic, authoritarian, or imperialist. But what is the meaning of the word rule of law? What is the secrecy behind the universal acceptance of the concept of rule of law? Such a worldwide utterance shows that the concept provides legitimacy to the governments who hails rule of law. However, the term implicitly or explicitly expresses the values of liberty, equality and justice. As a concept, rule of law stands for equality before the law, liberty of thought and expression and protection of individual and collective rights. George W. Bush claimed that it is the concept that asserts human dignity. How could an imperialist government hail rule of law, if the rule of law encompasses values such as liberty, equality, dignity and justice? This puzzle opened up the difference between the phrase rule of law and rule by law. Chinese law professor Li Shuguang said that Chinese leaders want to rule by law, not rule of law. The difference is that, under the rule of law, the law can serve as a check against the abuse of power. Under rule by law, the law is a mere tool for a government. Under rule by law, the government can suppress human liberty in a legalistic fashion. Rule by law is against rule of law. There are different opinions on the concept of rule of law among the political and legal philosophers. Many theorists believe that it is a contested concept. The term is meaningless because of ideological abuse and overuse. Brian Tamanahar observed that the social, political and historical context of the state provides meaning to the term rule of law. The concept of rule of law has a striking limitation in that its theoretical and philosophical discourse is starkly different from practical and political discourse. A.V. Dicey and F.A. Hayek is known as the vociferous champions of this concept. Hayek is the advocate of neoliberalism and unfettered market capitalism has no lenience towards the social welfare state. At the same time, Western democracies express their commitment towards the welfare state by the phrase of rule of law. We must be cautious about this ideological difference at the applicational level. A group of theoreticians notes that there is an inherent danger in the use of the phrase that it carries the dictum of lawyers and judges as plausible. The concept of rule of law is a millennium-old concept developed in ancient Greece and Rome. They were not libertarian governments. The philosophers of Greece, including Plato and Aristotle, were the exponents of rule of law. Aristotle said rule of law is the rule of reason, rule of man is the rule of passion. Passion perverts society. From this analogy, Aristotle pointed out the character of rule of law, that it is governed by reason. Plato noted that, we maintain that the laws which are not established for the good of the whole state are bogus law. The purpose of the law is the common good of society. In view of Plato, good is the divine order, that is connected with God. He considered law as the divine order and that is supreme. Aristotle and Plato never permitted minor transgression of the law, which ruins the state. Aristotle and Plato recognized two other conditions of rule of law, is equality and liberty. These concepts they used not in the modern sense of equality and individual liberty. Equality denotes equality of citizens and liberty denotes self-rule. Roman philosopher Cicero notes in the Law that a magistrate's function is to take charge and to issue directives which are right, beneficial, and by the laws. As magistrates are subject to the laws, the people are subject to the magistrates. It is true to say that a magistrate is a speaking law, and the law a silent magistrate. The predominance of law over the ruler is very clearly illustrated in the above said words of Cicero. Till the wake of the Holy Roman Empire, rule of law adhered and the ruler also had to follow and abide by the law. Justinian declared that the emperor possessed the lawmaking power and so is above the law. This idea perverted the fundamental basis of rule of law. The original premises of rule of law was rediscovered in the 12th century, during the age of Renaissance. During this time the jurists perceived that every act of the emperor is not considered a legal act. Thomas Aquinas made a remarkable contribution to the understanding of rule of law. He said, "Whatever law a man makes for another, he should keep for himself." Aquinas realized that the emperor is the lawmaker, so he is free from the coercive power of law, but he is the subject of God. And the ruler is subject to the natural law and divine law. Natural law is the law of reason and divine law is the law of God. From this understanding, the medieval century derived a fundamental principle of rule of law. That is, the sovereign is free from the coercive power of law, but he must follow reason and obey divine law and thereby he is the subject of his law. Germanic customary laws give much insight into the rule of law. There was no significant difference between law and justice in the Germanic view. The purpose of the law was to establish justice. According to Germanic customary laws, if the king failed to protect the law from infringement, it was the right of the people to dispose of the king. In this view, the king was the subject of law. Such an understanding acquired wide currency among the Germanic tribes in Europe. The key element of the Germanic law was that the ruler and the subject were bound by law and to law. In essence, no one was above the law. English revolutions played a vital role to restrain the power of the sovereign during the 13th century. Magna Carta insisted that the law of the land had supreme authority over the king. Thus the Magna Carta provides a strong foundation to the principle of the supremacy of law. Reformist movements also played a major role to restrain the power of the Pope and the king. The birth of bourgeois and liberalism in the late 17th and 18th centuries contributed new dimensions to the concept of rule of law. Liberalism envisages three types of freedom. They are political liberty, legal liberty and personal liberty. Political liberty means the right to self-determination, legal liberty means all are equal before the law, and personal liberty means everyone has a right to enjoy his natural rights. These rights are not unfettered freedoms but they are regulated by the law. The concept of liberty entails the concept of equality. Without equality, there is no liberty. Thus, we could find a new era of rule of law governed by the principles of liberalism since the end of the 17th century. However, there is an interesting question posed by skeptical thinkers, that how is an individual free under the law? If we look deep into this issue we can find that in a democracy, the laws are made by the people, and the government imposes restrictions by the law, and citizens have special autonomy to restrict the law. This peculiarity provides freedom to the individual under the rule of law. The rule of law is generally observed as a mechanism to protect individual liberty in an institutionalized form. The rule of law enhances human freedom by the separation of governmental powers in a horizontal line. The powers vested in government are divided into three compartments as the legislature, executive and judiciary, which prevents the accumulation of power into a single institution. The modern understanding of the rule of law is that the sovereign is the source of law and subject to the law. Thus the rule of law paves the ways to a democratic form of government based upon the principles of separation of power.